program. Advice and opinions expressed during the program are solely that of Melick Law, not WBEV or Good Karma Brands.
And welcome everybody to Taking Care of Business today with Rob Melick and Melick Law. Rob, how are you doing today?
Doing well. How are you?
Doing very well. We are, as you hear from all the Christmas music, we're in the full swing of the holidays. And, it's a hectic, busy time for everybody. I have to ask this question. How is your holiday shopping going?
Done. Absolutely.
You got me beat. Are you one of those guys that gets it done in like June?
No, I'm one of those guys whose wife gets it done in November. So
okay.
Yeah, no, we're all set. Got the boys all taken care of. So I've two sons. We're 14 and 12. So a couple nieces. So we got that squared away. So yeah, we're looking good there.
Now, 14 and 12, that's an interesting age for Christmas shopping. Oh yeah. Because once you hit those teenage years, what kids are interested in, they don't always tell you what they're interested in.
Right.
And that can make shopping interesting.
Well, we do have a surprise for the little guy. I don't think he's going to watch this video, so I think I can divulge.
Okay.
We decided to get him a phone. So.
That's a big step.
Yeah. Well, we waited till the start of 7th grade for the older one. My little guy's in 6th grade, but he's also old for his class. So my argument was he got it right around his 12th birthday. Well, he turned 12 in September, so getting it as a Christmas present kind of made sense. So yeah, he's going to be getting a phone here. So we'll see how that goes. But for the older one, like I said, 2 years of owning it plus years. He's only lost it once, so and we recovered it, so that was good. So if you'd asked me 2.5 years ago how many times he'd lose his phone, I'd say probably about 6 or 7. But one time I can live with. He left it at a lacrosse tournament. I had to go drive and pick it up from there, but at least it was found and not stolen.
Now I'm assuming when you say lacrosse tournament, you mean the game of lacrosse, not in lacrosse.
Correct. Yes.
Okay. Hopefully it was a shorter drive than that.
Yeah, it wasn't that far. It was out in Big Bend, so I mean it was probably about an hour from me, so not too bad of a drive, but. So the little guy has no idea that's what he's getting. He's been asking for a phone, making the same arguments. Well, Grady got it when he was 12. I'm 12. I should get it now. So we finally capitulated to those arguments and decided to make it a Christmas present for him.
It's amazing how well they remember when things happen for their siblings, and boy, oh boy, will they remind you.
They keep receipts, so they definitely know that.
And that's kind of an important thing to do. In general in life, it's good to kind of keep receipts on some things. One of the things I want to talk about, and this is something that we talked a little bit about this, behind the scenes on before with previous times that you've been in to visit. But it's official now. You've moved in. You've got a new office.
Yeah. Again, for most people in the listening audience, Beaver Dam is going to be my closest location. I work out of Sandy and Matt Heyer's office over at Heritage Mall. So I still have that office location, still working out of that office, but my main office is now relocated to Saukville. I was able to purchase a building in June of this year, and we finally got it renovated, and we opened up our doors officially on December 2nd. So that's where my paralegals are housed. So that's the new office location. So I'm excited about it. It's kind of neat to own an office building and actually run your practice out of there as opposed to paying rent. So so if anyone's interested, taking a quick trip to Saukville. For those of you who may not know, Saukville is just west of Port Washington. So it's right on the same Highway 33. So if you take Highway 33 east for about 45, 50 miles from Beaver Dam, you get to Saukville. So if anyone's interested in taking a drive, we'd love to see you and have you see the new office.
And I do want to stress again, because I did ask this before, and it's not going to stop you from coming to the local office. No. You still enjoy coming here and hanging out with the Hires.
Absolutely, yeah. I mean, like I said, I'm typically Beaver Dam at least once a week. I don't have set Beaver Dam hours. It's just kind of as client demand. Except for this, the third Monday of every month, I'm always here in Beaver Dam because I have the radio show anyway, so we try to schedule appointments before and after the radio show. So that one's pretty consistent. But as far as every other non-third Monday of the month, I'm here typically at least once a week, oftentimes 2 or sometimes even 3 times a week. So I enjoy Beaver Dam. I'm here quite a bit, so that's not changing at all with the new office location.
Well, we always enjoy having you in. Before we get into my first set of questions, let's remind anybody who doesn't know who you are a little bit more about who you are and what you do.
Sure. So I'm an estate planning attorney. A lot of attorneys are general practitioners. They may be doing a divorce one day, they may be filing a lawsuit the next day, doing an estate plan the day after that. I just focus on estate planning. That's the entirety of my practice. It's kind of like in the medical field. You have your general doctors, your family doctors that kind of see a little bit of everything. And you have your specialists. You have your cardiologists. You have your pulmonologist, oncologists. Those are people who focus on kind of one area of the body, and that's where they spend the majority of their practice on. So I would be the equivalent of one of those specialists, but in the legal field. So when it comes to estate planning, it's kind of a broad topic of documents, starting with incapacity documents, financial and healthcare powers of attorney, ranging to post-death documents regarding wills and trusts. And that's one of the main things I try to educate prospective clients about, as well as listeners on this show, the differences between will and trust-based planning, the necessity for powers of attorney. Anybody over the age of 18 should have those powers of attorney in place, and just making sure that people have an understanding of what the documents do. Again, this is not a sales pitch. I'm providing information. I always tell people when I meet with them, whether it's in a formal setting or an informal setting, I don't care what aspect of life we're talking about. I don't care. I mean, we're talking about estate planning now, but it could be anything. Nobody can make a fully informed decision without full and complete information. So that's what I try to do. Give people full and complete information so they can make informed decisions about whether they want to create an estate plan, or if so, what type of estate plan they want to create. And the plan that makes sense now may not necessarily be the plan that makes sense down the road. Right. Life changes. I challenge anybody listening here to say, is your life the same 20 years ago as it is now? Will it be the same 20 years from now? I mean, looking at my own life, 20 years ago, I was not married. 20 years ago, I did not have children. 20 years ago, I was a first-year law student. I mean, a lot of things change in time, and what I'm looking to protect, who I'm looking to have involved in my life was very different 20 years ago than it is now, and same thing 20 years down the road. I have two boys who are 14 and 12, and 20 years, I hope to be a grandparent. Right. Maybe I'm still practicing, maybe I'm not. I mean, there's any number of things that could occur differently, and the estate plan needs to keep pace with that. So that's one of the things that I talk to prospective clients about. It's not just the what I call set it and forget it mentality. A lot of people take that position when it comes to estate planning that, well, I've done it. It's all done. I don't have to look at it again. Well, it's good to get it out of the way. Having something is better than having nothing. But at the same time, if those life circumstances do change, we want to make sure that the estate plan is adapted accordingly.
And that's very, very true. Makes a lot of sense. Let me ask this as well for anybody who's listening right now. What are the ways to get a hold of you? Phone number, email, or website, or any of that? Yeah,
so the best way to get a hold of me is by telephone. Just an old-fashioned conversation. I may be a millennial, but that's the way that I prefer to communicate. That's the way a lot of my clients prefer to communicate. So my number for any of my offices, and by the way, I mentioned I have the office here in Beaver Dam that I use Sandy and Matt's office there. I also have the locations in Saukville, West Bend, and Germantown. Starting January 1 will be the Germantown office. The number for all those locations is 262-347-3444. Again, 262-347-3444. And it always starts with an initial consultation, an initial phone call. And again, when that call is made, people are coming from two areas. Either they have existing documents that they're looking to get a second set of eyes on, or they have no documents in place. Either way, I offer that free initial consultation. So again, for free, I will review existing documents, give you my recommendations, and you can decide, how or to what extent you want to implement the recommendations that I'm making there. So there's always a free initial consultation that can occur at one of those offices. I can even do it virtually. I do Zoom calls, telephone calls, and I also make house visits. If I have clients who have mobility issues, some clients don't like driving in the bad weather, some clients have young children and they don't want to have to hire a babysitter, so they can just plunk them down in front of the TV while we meet in the kitchen, whatever the case is. My goal as an estate planning attorney is to give my prospective clients as easy of an experience as possible to at least set up that initial consultation, because I know that it's a difficult thing for a lot of people to do. A lot of people don't want to think about their own mortality. They don't want to admit that this is something that they ought to consider. And I get that. I mean, I've been doing this long enough to understand that those are real reactions to it. So my response to that is to try to make it as easy as possible by offering those locations, by having it be a free initial consultation. I never charge for that initial consultation. And again, just making sure that people have that information, because that's what I do during that initial consultation, is just give people the options on a more personal, tailored level to make sure people understand what the documents are doing, why I'm making the recommendations that I'm making. So again, starts with that simple phone call for the free initial consultation, 262-347-3444. If you prefer to text, that's fine too. Just text me that initial client inquiry, and either myself or one of my paralegals will get back to you. I do also offer night and weekend appointments as well. I have some clients who have difficulty they work traditional 9-to-5 jobs. I'm not expecting people to take off work to meet with their estate planning attorney. Right. So you just let me know. I offer night and weekend appointments. I mean, even yesterday I did an appointment at 4 p.m. on a Sunday. So it happens, people, as long as it doesn't conflict with my coaching of hockey schedule, I'm happy to meet with people outside of normal business hours as well. Again, whatever I can do to make it as easy as possible. One other thing is that if you do decide to give me a call, please mention that you heard me on WBEV or you saw me on dailydodge.com, and I do afford a 20% discount to WBEV listeners and dailydodge.com viewers. So mention you heard me there, and we'll take 20% off the legal bill for you.
There you go. That is a great deal. Now, obviously, this time of year, it's Christmas. We're all going to be traveling to see family. I know I'm going to be seeing quite a bit of family over the Christmas holiday, and I find it's a great time to have those conversations because it inevitably tends to lean that way anyways. Because when you're catching up with people, a lot of times it's okay, who got married, who had children, heaven forbid, who passed away. And these are all life-changing events, which can have a huge effect on what's going on in your world. And especially when it comes to things like family members passing on, it starts leading you to think about your own mortality a little bit. And that's usually when it's a good time to start saying, like, well, what do we have in place? What do you have in place? And it can be a real eye-opener to find out that a lot of people don't have anything in place, but they think just because they got a handwritten note in the safe somewhere, that's good enough.
Yeah, and again, it's, people think of the holidays, they think of joy and merriment and people getting together, and that is at its core what the holidays are about. But again, when people get together in large groups like that, I frequently will get a lot of calls in January, people saying, we had a Christmas gathering and someone told me about your services and how you help them out. And so it is a topic that does come up. I mean, it's not the main topic of conversation, nor should it be, but it typically is something that in my experience does come up when family gets together. Somebody, like you said, somebody passes away, how'd that experience go? Well, it went well because they had this, or it didn't go so well because they didn't have this. I mean, that tends to be the pattern I see quite a bit in my practice. People who don't have estate plans or people who just have will-based plans and they realize the estate has to go to probate in most cases. They say, what are the alternatives? What can we do to avoid this? So, again, I do get a lot of clients calling me after the holidays for exactly the reasons you just described. They got together with family members. They learned about options that are available that maybe they didn't think about before. Maybe, someone died younger than they should have, and they said they kind of have that shock moment where they realize their own mortality and they decide to do something about it. So those are very common occurrences for sure.
Now, another thing that we've talked about before, and I want to touch on this because it came up as a conversation recently in my family locally. My oldest is now out and on their own, and they're living with their partner, and they're very happy. And I said, you guys may want to discuss what happens if one of you gets sick, because the hospitals won't talk to me. You're an adult. They're not going to talk to me unless you say something, put something down, have a directive in place, something that says that they can talk to me.
Right.
They're not going to talk to your partner. It doesn't matter that you live together. It doesn't matter how long you've been together. They don't care. They're not going to talk to them. And there's a lot of misinformation about stuff like that out there on the internet. They tried Googling it themselves and said, as long as I have something in my pocket that says they can talk to so-and-so, that's good enough or whatever. And legally, that's not. There's a lot of trouble that can happen if there isn't real things in place.
That's exactly right. And, you talk about partners, you talk about people having parents. Even if you're legally married, it's irrelevant. The example I give is this. Again, I do what I do for a living. Obviously, I'm a little biased. But let's say I didn't do what I did for a living, and I'm driving from here to my next appointment. I'm going back to my Saukville office, taking Highway 33 from Beaver Dam back to Saukville. The majority of that drive is 55-mile-an-hour divided highway, 2 lanes. Someone crossed the double yellow, hits me head on, I'm taken to the hospital, I'm in a coma. My wife, we've been married 17 years. If I don't have a healthcare power of attorney nominating her to make those decisions, she not only can't make decisions for me, she can't receive any information regarding my condition, my status, my injuries, nothing, because sharing that information without my consent, I can't give consent if I'm in a coma, violates my HIPAA rights. So, the example you just described, and again, I'm not suggesting, what your child may or may not have found on the internet, but based on the story you just described, the problem there practically is how do we know when that document was written? Are there witnesses? We don't know any of that.
Right.
So it has to have the legal enforceability to be able to have some medical professional rely upon that information. And healthcare powers of attorney have that information. They can say that these two witnesses saw this person execute this document. They were of sound mind, sound body at that point in time. A random note in a wallet is wholly unenforceable in that regard. So, yeah, and again, you mentioned a partner. A lot of times people will think parents automatically have that right. I could tell you this, the moment a child reaches the age of 18, regardless of what their living status is at that time, parents lose the ability to make medical and financial decisions. They lose the ability to receive information regarding that person's medical care unless they have a power of attorney. That's the only way to do that. And people may say, well, that's crazy. You know, the average 18-year-old in the state of Wisconsin is a senior in high school.
Right.
The average 18-year-old in the state of Wisconsin is still living at home. The average 18-year-old in Wisconsin is still under their parents' health insurance. None of that matters. They are 18. They are now protected by HIPAA, which is a federal statute called the Health Insurance Portability and Accountability Act. That statute determines when and under what circumstances medical providers can share your medical information. Now, as a general matter, we like that our medical information is protected. We want to be able to be candid with our medical professionals and not risk having them share that information. That is generally a good thing. The problem is that if we are incapacitated, we cannot pick and choose when and how medical providers share that information. Either they have authority through a healthcare power of attorney or they don't.
Right.
It's really that straightforward. And having these powers of attorney in place is a very quick, very inexpensive method to give parents or partners, whomever it is, spouses, whomever it is, the ability to make those medical and financial decisions. Because I always tell my clients this, when it comes to powers of attorney, when it comes to a lot of the work I do, fortunately, these are things that are unlikely to occur.
Right.
It is unlikely that your average, if you picked 1,000 random 18-year-olds in the state of Wisconsin, what are the odds that any one of them is going to get in an accident or have some sort of medical condition that prohibits them from being able to make financial and healthcare decisions? I don't know what the answer to that is, but I know it's not zero.
Right.
If you make the group large enough, you're going to get people who are in there. The problem is we don't know which group we're going to fall into. Are we going to fall into, let's say, the 1% that have that occur, the 99% that doesn't? We don't know. So why take the chance? Why not have that set of documents in place to make sure that parents, partners, spouses, friends, whomever you nominate, has the ability to make those medical and financial decisions? To me, it's a very easy decision. The moment you turn 18, get those powers of attorney done.
And I mean, we live in a world with a lot of misinformation out there. I think about, just I'm going to use one source of media that we all have access to, the television. Sure. You know, we watch a show, ER type show or Grey's Anatomy or whatever, and we've all seen the episode where a kid gets wheeled in somewhere or a spouse gets wheeled in, and then somebody comes in and wants information, and they're crying at the desk, but that's my husband, that's my kid, that's my wife, whatever. And some bleeding heart doctor's like, oh, well, I'm so sorry. Yeah, but in that case, sure, come on in, let me tell you everything. That's not how it works in the real world.
It makes for good television. If they said nope, can't do it, then they had to go to court to get somebody appointed. I don't think many people would watch that show.
Right, it becomes a whole different thing.
Right,
Yeah.
and that's kind of the nature of what I do for a living. I mean, yes, there's a lot of legal dramas on TV, but there's none about estate planning. It just doesn't work that way. It's not entertaining. It's not fun, for lack of a better word. It's not, the attorney making the closing statement in the court and banging the table and things like that. I mean, that's what people like, So it doesn't mean the work is any more or less important. It just means it's not conducive to television, I guess would be the best way to say it. But yeah, I mean, I'm just telling you what the law is. The law says, and again, could you get a doctor who is that sympathetic doctor? Sure you could. But why take that chance?
Yeah.
The example I give is this, and I think this tends to resonate a lot more with people, to use, again, something that makes it a little more understandable. I'm sure every single one of us has sped at some point in their life.
Yeah.
Okay? Right? If you're going 36 and a 35, you're speeding. Right, you're going to get pulled over. I'm sorry, you're breaking the law, but you're probably not going to get pulled over.
Right.
Going 36 and a 35, you could get pulled over,
Right.
but you don't know. Right? You start going 56 and a 35, you're probably going to get pulled over.
Yeah.
And that's kind of thing. The problem is you don't know what the nature of that police officer is that day. You don't know how much they're paying attention. You see a cop car. Maybe he's not even running radar. Maybe he's catching up on paperwork. I mean, you just don't know. Kind of the same thing. The only guaranteed way to not get pulled over for speeding is to not speed.
Right.
The only guaranteed way to avoid a situation where you cannot make medical or financial decisions for, again, an adult child, a partner, a spouse, a friend, whomever, a sibling, is to have these powers of attorney in place. And it's very easy and very inexpensive to do.
Let's move out of the hospital conversation and start moving into a little bit more about end-of-life planning. I think I'm going to be quoting you here when you say that, I think you once said, life has a 100% mortality rate.
That's right. And it's funny because we just talked about a scenario where it's a low incidence rate, right? You know, where people are going to be incapacitated after they reach 18. Now we're going to the opposite end of the spectrum, where we do talk about a 100% mortality rate. So every single person needs to be aware of end-of-life planning because we're all going to go. We're all going to pass away. We don't know when, we don't know what circumstances, but we know that we're going to pass away. So powers of attorney, I'll just finish that point and then move on here. Powers of attorney, what I call pre-death estate planning documents, because you're incapacitated. By definition, you're still alive if you're incapacitated, hence pre-death. Well, post-death now, that is something that, again, we're going to need. We know that at some point in time we're going to pass away, and making sure we have an appropriate plan in place is a given, given that 100% mortality rate we talked about. What I'd like to explain to people here is the difference between will-based planning and trust-based planning, because you talk about misconceptions, you talk about misinformation. This is another area that's kind of rife with that. If we were to play a game of Family Feud and ask 100 people what's the first word they think of when you think of the word or when you hear the phrase estate plan, I think will would probably be the number one answer.
That would have been the first I'd pick, yeah.
You bet. I need a will. I should have a will. Well, what I like to explain to listeners of shows, seminar attendees, clients of mine, people seeking a consultation, is explaining first and foremost what a will is, what it does, and then maybe more importantly, what a will doesn't do. Okay? So I always start with what a will does. And at its core, there's three things that a will does. Two of them are always going to occur. The third one is only in certain situations, but in those certain situations, I'd argue it's the most important thing an estate plan can do.
Okay.
So let's break that down. The two things a well-drafted will is always going to do. One, who gets the money?
Which is the big question.
You bet. Who are the beneficiaries? Who or what, in the case of charities, are going to receive the proceeds of your estate after you pass away? Not only who gets the money, but under what circumstances. I mean, the example I give is that we may not necessarily want to turn money over to an 18-year-old, right? We can't turn money over to a minor, but we may want to wait until they're a little older than 18. So we could put provisions in place for that. Second thing the well-drafted will does is indicate who the executor is, who's in charge. That person's job upon passing is to shepherd all the assets into the estate, pay off any final expenses, and then distribute the proceeds in accordance with the deceased person's wishes. So those are the two things a well-drafted will always do. Who gets the money, who's in charge. The third thing only applies to certain circumstances, as I mentioned, but for those of whom it does, or for whom it does apply, it's probably the most important thing we're going to talk about here today. And that is the ability to determine guardianship of minor children. Okay? You mentioned TV shows, okay? And if people are going to judge me for this, I apologize. But I'm not a big Netflix binge TV show watcher. But I did get into one show. Okay. That show is Shameless. I don't know if you're familiar with Shameless.
I am familiar with Shameless.
Phenomenal show.
William H. Macy, good
Absolutely,
show. Yeah.
Yes. It's incredible. And there are two different references in that show to guardianship of minor children, and they both got it wrong. They're saying, well, I talked to my dad, he's going to be the guardian, or, I'll write it down on a piece of paper. Completely unenforceable. Maybe it is under Illinois law where Shameless is, I don't know, but I could tell you in Wisconsin, the only way to determine guardianship of a minor child is if it is in a will or a trust. Literally nothing else works. You could have a letter notarized by 10 different notaries with 100 different witnesses, completely unenforceable unless it's in a will or a trust. So again, emphasizing my point from before, for those in the audience who have minor children, or perhaps those in the audience who have minor grandchildren, they should be telling their children this. the only way to determine guardianship is through a will or a trust. It has to be contained in those documents. And again, I'd argue that's the most important thing. At the end of the day, money, I'd rather save money. I'd rather not have it be wasted through probate, which we'll talk about more in depth later. But the most important thing I can do in an estate plan as someone who has children who are 14 and 12 is to say, if my wife and I pass away, who gets to serve as guardian? There's literally nothing more important than that. So making sure that if you do have minor children, that you have a will or a trust in place just for that reason. So that's something that I want to emphasize here as well.
Right, and that does clear up a lot of arguments, because I think back to when I was young, the first time I was told, like, oh, this is your godmother and godfather, and I was like, oh, what does that mean? In my parents' mind, that meant, well, if something happens to us, they take you.
Yeah.
But then I know I have aunts and uncles who would have been like, no, that should fall on us because we're the siblings.
That's right.
We're the aunts and uncles. We should be doing it. And that could have been a whole argument because there was nothing in place.
And it could be grandparents, and it would be an argument. What would happen is, if your parents passed away, they'd go to court. Every side would make an argument, and the judge would ultimately do the best he or she could do to determine who that judge believes would be in your best interest to serve as your guardian. I mean, they use the standard of best interest of the child, which is a great standard, but really, what are they deriving that from? A couple days worth of testimony from lawyers? I mean, that's really what they're doing. So as a parent, why not take the step to make sure that you get to choose who serves as guardian? Because what I will tell you is this. I'll tell you two quasi facts about it. Some of these are more anecdotal, but one of them is this, is that what I found in my experience is guardianship is almost as important to determine who is the guardian as opposed to who is not the guardian. Because I can tell you there are many situations where I've come across where someone says, I am okay with anybody except for blank. They just don't want this person. And typically that person is oftentimes the person with a lot of means who might be able to hire the best attorney to make the best argument to the court. The other thing is this, which kind of surprised me. A first-generation lawyer here. This is one of those, you don't learn this in law school. You can only learn this in practice. I'd say just under half of my clients who have minor children elect to have a non-family member serve as the guardian. They pick a family friend. They pick someone, because, they run in similar social circles. Maybe they have children about the same age. They go to church together. They go to school together. They play sports together. They live close by. Well, whatever the case is. I mean, there's any number of reasons why it may make more sense. And what I can tell you is, if we have that hearing where the court hears the testimony, a court is going to be very hard-pressed to award guardianship to a non-family member. That would be a very difficult thing to do. But if there's a will that says we want it going to our friends, we want it going to our neighbors, then the courts have to enforce that. So again, I'd argue that's the most underrated aspect of estate planning. People just don't think of that. In fact, when I coach sports, I coach football, I coach hockey, it inevitably comes up, well, what do you do for a living? And I explain that to them. A lot of times the response I'll get from parents is, well, I'll keep you in mind down the road when I get old. And I said, well, you may want to keep me in mind now, because I know I'm coaching your child here in sports, and if something happens to you and your spouse, courts are going to be determined guardianship. Well, what do you mean? And it's kind of the same thing. Well, I have a letter. My the godparents are going to, well, no, they won't.
Right.
At least under Wisconsin law. Again, I can't comment on other states, but I can tell you in Wisconsin, if it's not in a will or a trust, it's completely unenforceable.
Now, this may come across as a completely stupid question, but I assume there's not a situation where you can be like, oh, I'm going to put it in my will that, the kids go to, Tom Cruise, and you don't tell Tom Cruise they're coming.
Right. Well, Tom Cruise has the ability to reject that. So, again, if you nominate someone, and that's the other importance of having the documents up to date, especially with guardianship. The example I give is this, is that when I created guardianship paperwork for my children, the world was different 14 years ago than it is now.
Right.
The example I give there is, my sister. My sister at that time was single. She was living in a condo in downtown Milwaukee. Well, now she has a child of her own. She's in a much better position to serve as guardian than she was 14 years ago. So they need to be updated as time occurs. But again, if that hypothetical were to occur, Tom Cruise is not required to take that child on. So he rejects it. And if that's the only guardian that's listed, then the court is back to square one as though you didn't have it in place. So while it's not legally required to obtain those people's consent for guardianship, practically speaking, it's probably a good idea, because you want to make sure that those people are willing and able to serve in that position.
That makes a lot of sense. I do want to remind people as we continue the show that this is a paid program, and advice and opinions expressed during the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. Talking about that need to update and keep things going, that's why these things are kind of living documents until you're no longer living to make it a living document.
Right, and that's exactly right. I mean, just going back to I'll just use this example. Right now, as I mentioned, my boys are 14 and 12. Right now, they have one role under the estate plan, beneficiary. That's it. They get the money held in trust until they're 30 if my wife and I pass away.
Right.
That's it. Well, 20 years from now, when they're 34 and 32, I hope they have more substantial roles under the plan. I hope they're the ones making medical and financial decisions for my wife and I. I hope they're the trustees of their own trust at that point. In fact, I'll go as further to say as I hope one or both of them are doing this radio show in 20 years while I'm hanging out with my grandchildren, right?
There you go.
I mean, that's the goal, of course, right? So, but these things do change over time. I guess that's my point. Like making sure that these documents are living documents, make sure that they do remain intact. Because again, what I found is this, and in my job, I mean, I like talking to people. It's just kind of the way I'm wired here.
Right.
But yeah, I find so many people who, when they met with their attorney, they just said, okay, well, it's done, it's done. They don't have to do any more. And I don't know if it's the attorney who's spreading that information. I don't know if it's the clients are misunderstanding. I don't know if things just got lost in translation. But I can tell you, just from a logical standpoint, they can't be documents that just stay in place. There's too many life circumstances, as you said, that cause people to want to update their documents, and they need to be updated. And what I can also tell you is this: at my firm, if I draft the underlying documents, there are no charges for revisions to the documents. So that's something that I build in, and I don't know of many other firms that offer that. Right. A lot of other places, it'll just be, all right, well, you want revisions, it'll cost you X number of dollars or Y hourly rate or whatever the case is. So again, what I try to do is I try to give my clients that certainty just for the reasons we described. If I have a set of clients who have documents that they know are no longer the way they want things going, right, either from a who's in charge standpoint and or who gets the money standpoint, they're tough. They're stuck in a tough spot. Either they have to live with out-of-date inferior documents or they have to pay to make those revisions. Well, at my firm, I've eliminated that. I've said, you do those underlying documents with me. There are no charges for revisions to the documents. So that's my way of trying to give a little bit of a value add to my clients. That way they don't have to be stuck in that difficult choice of, well, is it worth updating the documents or not? It is worth updating the documents because it's important to make sure that the people you want making decisions and the people or things you want receiving the money are, in fact, in place and, in fact, are updated to reflect those lifestyle changes.
And I mean, we have to make abundantly clear that none of us really, for the most part, get to plan when these life-changing events happen.
That's right.
Where these documents may need to come into play.
Yep.
And so saying like, well, I know I just bought a house and, and just made some huge investments and, came into some money or whatever, but I don't need to make any changes because I just saw, Rob, 6 months ago.
Right.
No, better to do it now.
Absolutely. Well,
for all you know, tomorrow could be.
Right. And like I said, you do have control about when you buy a house.
Right.
The four main life events that cause people to want to update their estate planning documents, though, at least three of them are not planned for. One is quasi-planned for, depending on what your circumstances are.
Right.
I talk about the 3 Ds and a B: death, divorce, disability, and birth.
Right.
Well, certainly as far as death, disability, and birth, we can't really plan those. I mean,
right,
with birth, you can kind of plan it, I suppose, right?
Right.
But you may not have say in it. If it's the birth of a grandchild, that's out of your control about when and how that grandchild is born. Clearly,
right,
you can make some decisions about whether you want to have additional children, right? But as far as the birth of additional people, that's outside your control. And then divorce, at least at some level, can be out of your control.
Right.
But again, if it's a divorce of another family member, that's outside your control. So those are the 4 most common life events that will cause people to want to update their estate planning documents because, again, if any of those events occur, the people that you want receiving it are going to change now. If we have disability, and that's another thing that comes up all the time, is supplemental needs planning. If I have a beneficiary, and that could be a child, a grandchild, whomever, that is receiving governmental benefits, if we don't plan for that through a supplemental needs trust, which is a different kind of trust than just a regular revocable living trust, then that beneficiary could lose their governmental benefits. In other words, the thought process is that if somebody is receiving governmental benefits due to a disability that they have,
right,
okay, let's say they have Down syndrome, they're receiving governmental benefits because they lack the ability to work. Well, if that person in their individual capacity receives an inheritance, the government takes the position of, well, what do they need benefits for?
Right.
They have this inheritance coming in. So what is the net effect of that? The net effect of that is you are dollar for dollar disinheriting that child because they're going to lose governmental benefits in an amount equal to whatever inheritance they're receiving. So the workaround for that is you can create what's called a supplemental needs trust, which allows the beneficiary to benefit from it but not have access or control over the money. So those are things that could occur now or could occur down the road. I mean, the example would be if someone has Down syndrome, they're going to have Down syndrome. They're not going to improve from that.
Right, that doesn't go away.
Right. Or someone could be reasonably healthy right now and get in a car accident, become a paraplegic, unable to work. Well, that's something that we didn't know in time one, but we do know in time two.
Right.
So those are just examples of the importance. That's why disability is one of the 3 Ds and a B. We have to make sure that we're aware of that and we account for that appropriately in the estate plan. Because the old line of thinking was, well, we'll just leave the money to the other children or the other beneficiaries with the hope that they'll take care of their disabled child.
Right. They'll feel obligated.
Right.
Right.
And, moral obligations are great, but I like legal obligations better, right? Because legal obligations, there's no wiggle room from.
Right.
We require a certain set of actions by making it legally enforceable. So again, from that perspective, having the supplemental needs trust in place allows you to do that. Plus, just as a parent, you feel badly about excluding a child. Right. I have a lot of clients who say, gee, I don't want to exclude Johnny. I love Johnny just as much as my other kids. I want to make sure that Johnny's taken care of, but you have to do it in an intelligent way, because if the only options were put Johnny in the estate plan or completely disinherit him, right? A lot of people would choose the completely disinherit him part if it's just a matter of principle of having that person in the document. But now we can have it even better than that. We can still provide for Johnny, but we can make sure Johnny's share does not cause him to lose any governmental benefits that he's receiving.
Now, we talked about the D's, we talked about a B. I want to talk about a word that starts with P. Yep. It's a scary word. It's I consider probably a 4-letter word in the post-living scenario, and that's probate.
Yep. So let's define probate quickly. Probate is the process where a court oversees the administration of an estate. When an estate goes to probate, there are a series of hearings, a series of filings, a series of deadlines, a series of events that occur before assets go from the name of the deceased to the name of that person's beneficiaries. I will tell you this. As an estate planning attorney, my goal is to encourage my clients to create plans that are guaranteed to avoid probate. Not likely, not highly likely, but guaranteed.
Right.
Why? Why is probate avoidance so important? 3 reasons. First is cost. Average cost of probate in a state right now is about $8 to $12,000. Second is timing. Average length of probate is about 12 to 18 months. Third is publicity. Wills become public record when an estate goes to probate. Not only does the will itself become public record, but the amount and the character of the assets also become public record. So to summarize, cost $8 to $12,000, timing 12 to 18 months, public record. How do we avoid probate? And this kind of ties very nicely in with our discussion of wills versus trust, because the only way we avoid probate under Wisconsin law if we have a will is if we have less than $50,000 worth of probate assets. Okay?
So generally, if you own a home, you're already done.
Right. So if we just have a will, and that's the only estate planning document we have post-death, and we have more than $50K, you own your home, you have more than $50K in equity, the estate will go to probate. The only other way to avoid probate, the only guaranteed way to avoid probate, is to create a trust. And that's why I'm such a fan of trust-based planning, because it creates the certain outcome that no matter who passes away when, no matter what we own at the time we pass away, we are going to avoid probate. Now, the type of trust I recommend is what's called a revocable living trust. Revocable. Now, most people know what the word revoke means in everyday conversation, but from an estate planning standpoint, 2 important things. 1, you have the ability as the creator of the trust to make whatever changes you want at any time. Again, we talked about 3 Ds and a B, but there's any number of life events that could occur. It would cause people to want to update their documents, and because the trust is revocable, you possess that ability. The second, and maybe more important, at least in the short term, is that with a revocable living trust, the creator or the creators of the trust have full use, full control, full access over trust assets. We talk about misconceptions about estate planning. One of them is that if I have a trust, I have to ask permission of the trustee. There's restrictions on how I can use assets. And yes, there are some trusts out there that place those restrictions, but a revocable living trust is not one of them. With a revocable living trust, your ability to do what you want with what you have is exactly the same as it would be before and after the creation of the trust. But again, Having that trust in place is what guarantees the estate avoids probate. So there's a lot of people that I come across who just have wills. And the question is, will that will avoid probate? And the answer is maybe. We don't know. The trust, on the other hand, provides the guarantee. So that's why I'm a fan of trust-based planning.
And I know you've said in the past that, like, you as an individual will eventually pass on. We've said that before, 100% mortality rate. The trust doesn't die.
That's right. That's the other advantage to it. Whereas with a will, you're relying upon named beneficiaries. And so I'll just use my own situation. It's a tough one, but I'm a big boy. I'll deal with it, right? I have 2 sons, 14, 12, as I've mentioned a couple times here. I have no idea whether either or both of them are going to survive me. I hope they do.
Right, fingers crossed.
I want nothing more than for my kids to survive me, right? But unfortunately, that's not a guarantee. I can tell you with 100% certainty, my trust will survive me, because the trust can never die. And that's kind of the whole crux of trust-based planning. We create an entity that cannot die, and we fund that trust, and that's how we guarantee that the estate avoids probate.
I mean, it sounds like that almost seems like a no-brainer for the direction you should really go. Is there any particular reason why people, when you present these two things to them, say, no, I just want a will. I don't want a trust. I just want a will.
Yeah, well, for some people, wills make sense. I mean, if you're renting and you have relatively minimal assets, go with the will. That's no problem. Or I do have some clients who are in a situation where they have 8 or 9 different children, and the odds of all 8 or 9 children predeceasing, okay, yeah, that's pretty low. Maybe the will-based plan makes sense there. But again, the analogy I give is we all have homeowners insurance. Mm-hmm. Unlikely our home is going to burn down. For any given person with homeowners insurance, you're going to pay a lot more in premiums than you're ever going to get in terms of a payout. But we do it because we want the certain outcome.
Right.
Kind of the same thing here with the trust. And that's what I encourage my clients to think about. Now, to be candid, yes, trust-based planning is going to be more expensive than will-based planning. So some people will just create the will kind of as a stopgap now. Young families, I mean, that would be an example there. If the main goal you're looking at is being able to determine guardianship of minor children, at least in the short term, create the will now. Now, what I always tell my clients also is that I have built-in credits. So if I have a young couple who creates a will with me in time 1, they decide to create the trust in time 2, which happens a lot.
Right.
I defray the cost of the will-based plan from the cost of the trust-based plan once they decide to proceed. Now, I can't guarantee my rates will stay the same. In fact, they won't stay the same. Everything goes up. It's just kind of the way it goes, right? But at the same time, whatever you paid for the will in time 1 will serve as a credit off the cost of the trust in time 2. So that way, at least you're having that base level of planning. You're able to create powers of attorney so you can make decisions for your spouse. You have the ability to nominate guardians of the minor children. You don't get probate avoidance yet, but you have a cost-effective way to at least deal with the immediate, running the risk that the estate may go to probate down the road, but then you have time to create the trust at some later point. So I do run into a fair amount of clients who decide to go that route, and it works out for them.
I want to talk a little bit about timetables. So you had said with the route, if something does have to go to probate, you said 12 to 18 months, plus the money that's involved, all of that. There's deadlines and things. If you go with the revocable living trust, what is the time frame with which that kicks in?
Yeah, so the first thing I need to do is I need to get a death certificate. So once I get a death certificate from my clients who create trust with me, I create what's called an EIN number for that. Basically, it's a tax ID number for the trust. It takes about 10 to 15 minutes to create that, and then they're off to the races to collect the assets. So usually, and again, it does vary. I mean, the example I give is this. My wife and I die tomorrow. Okay, that trust is going to be open for a while because my boys, like I said, 14 and 12, we don't have them getting the money until 30, so the trust can be open a while. But for most people who have adult children and they pass away eventually and there's no restrictions on the time in which they can receive the money, usually the trust is open for maybe a month or 2. It's very quick. Now, the only other mitigating factor would be real estate. For most people, real estate is the only asset that they can't just fill out a death claim form to receive. You have to find a willing buyer. You have to sell the house. You have to have a closing. You have to do all that. So depending on the market, depending on the condition of the home, depending on the location, depending on the asking price, that could take a while. But I'd argue that would be the exact same amount of time as you'd have if you were going through probate anyway, let alone everything else you have to do to open and close the probate matter. So again, I'm a fan of living trust because they create the certainty. There's a lot of uncertainties in my world. There's a lot of uncertainties in the world in general.
I'll say, definitely.
Right, but I will tell you that the 2 certainties are, is 1, we're all going to pass away at some point, and 2, By creating a trust, we're going to avoid probate.
So what I'm hearing is for all those people out there who are going to be sitting around the Christmas table, enjoying a meal, talking with family, if anything even remotely close to planning for certain situations like this come up, you may want to give Rob Melick here a call and find out the real answers to those questions. Don't trust everything you read on Google. That's for sure.
You bet.
Let's remind everybody again how to get a hold of you. Make sure I got the phone number correct. I've got 262-347-3444.
That's correct.
And then give you a call there and just chat with you, set up a time to get together. And then, of course, you've got the new office in Saukville. You've got the time you spend here in Beaver Dam with the hires.
Correct.
And then where are your other offices again?
West Bend, and it'll be Germantown starting January 1.
There you go. Definitely worth checking out. We have just enough time for me to ask you, are you traveling for the holiday or are you staying relatively local?
Oh, we're staying local, so that'll be good. We're looking forward to that. The boys have hockey, so they got it sandwiched between the holidays, unfortunately.
There you go.
So
They both play?
They both play, yeah.
What roles?
I have my one son is my youngest son is always a defenseman, so that's the team that I'm coaching on. And my older son, it varies. He mostly plays left wing, but he'll play some defense every now and then too. So,
all right.
Yeah, I have a bantam and a peewee. If you're familiar with the age levels there,
Yep.
So. Yeah, the bantam's the older one, the peewee's the younger one.
That's
so.
an exciting time. And are you a hard coach or are you?
No,
pretty
I'm a softie. People joke with me about that all the time. So I'm harder in hockey than I am in football, though. I will tell you that football's a much more mental game, so that's more my level. I'm the offensive coordinator as well as the head coach, so coming up with plays and schemes and everything is more my style. Whereas hockey's just be aggressive, get after the puck. So
there you go. I like it. I like it. Well, Rob, it's always a pleasure talking with you. I always feel like I get very well informed when you're here, and I look forward to talking to you again soon.
You bet. Happy holidays.
Yeah, same to you. This has been a paid program. The advice and opinions expressed during the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands.